All right, everybody. So we're back with another episode of our asset protection series. Today's guest really shaped, in many respects, our practice with respect to our approach of asset protection, not just including the things that you typically think about with asset protection, but to expand that scope to be more really a focus on wealth preservation, keeping what you have. I've had him speak on several occasions. He's a featured speaker around the country for medical organizations and associations. His name is Ike Devji. He is an asset protection attorney, and I think it's critical that people, especially for my physician clients, we have specialists, we have estate planning attorneys, we have asset protection attorneys, we have contract attorneys. And so as we're seeking out those relationships and working collaboratively, it's critical that we know which lane these folks, these experts are in. And Ike is certainly at the top of the list in the asset protection space. Sought after speaker, writes myriad articles that are published. I can't even keep up with how much stuff you publish. It's actually pretty remarkable to me. And so Ike, thanks for being here today. And if you wouldn't mind, just kind of share a little background on you, how you really kind of, why you're passionate about this, how you got into this. Just kind of share with me a little bit about you.
You bet. Well, first of all, thank you for having me on, Anthony. I appreciate that. And I hope we can share some information that helps your friends and colleagues and clients. And thank you for that embarrassingly glowing introduction. I'll give you the sort of the 10,000 foot view since you've been so kind in your introduction. As you said, I am an attorney. The sole focus of my national practice is asset protection planning. So it is the only thing I do, and that I've done for the last 17 years. My client base is national. We work with clients from all over the country who are referred by other clients, by their advisors. Often their CPA or attorney or financial advisor will send them to us. The people I protect include a couple of thousand physicians in every specialty. That includes medical, dental. We also protect a higher net worth group of another several thousand business owners, and protect about $6 billion in personal wealth for that client base. The planning we do is proactive. I'm just a lawyer. I don't sell any financial products or anything else, but we also look at risk management very heavily, and that often does involve tools like liability insurance and other things. And what we really try and do is keep people out of harm's way in the first place and have a backup plan for if that doesn't work.
That's great. I mean, I'm pretty sure this was you. You used to say, and maybe you still do, own nothing, control everything is kind of the overall goal. If I massacred that, I apologize. It's something, a paraphrase.
I certainly didn't invent that. That's an old phrase, but it certainly does apply to asset protection planning. And what that really means is that you don't need to hold all of your assets personally. You can use the law and appropriate legal structures to segregate assets from you, from your other assets, and from your personal and professional risk. So that's certainly one layer of the planning for sure, is making sure that we have title to assets in the right place. There's no use, for instance, being a fire doc who's living lean and saving every penny and following your advisor's advice if all of those savings get taken away from you. So that's how we complement what guys like you do.
Excellent. So I feel like the natural place to start, you are an attorney, you focus on asset protection. What is it? What is asset protection?
Well, I wish I could say it was just one magic thing that I could put in a box and sell to you, and I'd be retired and so would you. It is unfortunately, or fortunately, maybe that we know, a combination of several different things, and I describe asset protection as having three layers. The first one we euphemistically refer to as clean living, right? Which that means compliance, following best practices, following the law, doing things ethically, being a good leader, being a good manager, controlling behaviors that keep us out of trouble in the first place. So the first layer of asset protection is the client themselves. The second layer of asset protection planning is liability insurance in all of its many forms. Most docs are only concerned about med-mal claims, so they focus on their med-mal insurance. And if we're lucky, they have some adequate personal liability insurance on their home and their car. but there are about 6 other layers of commercial insurance that most physicians need and many overlook. And then finally, the last layer of asset protection is legal planning. If our compliance fails, if there's a mistake, if there's an accident, and if our insurance fails, let's have legal tools in place to back all that up and limit any claim in the future, which we have a legal right to do today. So in my view, that's what asset protection planning is. It also must involve guys like you. We need to make sure that any source of avoidable loss or risk is addressed if we can identify it. So we need guys like you identifying market risk. We need guys like you identifying tax risks and exposures that clients could avoid if they had better planning. So that's part of it as well. So ideally, it's holistic and involves insurance planning, tax planning, and legal planning.
No, that's great. Very well summarized. You hit the word malpractice, so I would like to key in on that. Share a quick anecdote. I have a good friend of mine who's a physician. Years ago, he was reading some of my papers, which again, not as voluminous as yours, but nonetheless, he was reading one of my papers and he said, "Hey, Anthony, I have to ask you a question. A lot of your articles talk about the risk of loss and talk about these various risks." He goes, "I have malpractice insurance. I feel good. I don't really understand some of these things." I proceeded to share with him some thoughts, but let's move beyond malpractice because I feel like that's a common sentiment. What are the risks, particularly that physicians, of course, it's other white collar professionals as well, but what are these other risks beyond malpractice that we're really talking about under this umbrella of asset protection?
Sure. Well, I mean, I think we can best answer that question by breaking those risks into 2 buckets. So first of all, let's talk about professional risk. If you're a physician, medical malpractice is not your only professional risk. That is especially true for clients who are owners or partners in a practice, as opposed to maybe those that are employed. If you are a practice owner or partner, not only do you have all of the complexities of healthcare law, HIPAA compliance, billing compliance, Medicare, Medicaid compliance, right? All of that complexity, you have all of the same liability as every other business owner in America. So some people think, well, I'm running a doctor's office. And no, what I say is you're running a business that has additional liability and compliance on top of every other business. So let's talk about some of those professional risks. For instance, the risk of an employment lawsuit is a huge risk that most physicians are underprepared for. They don't have, in many cases, custom drafted state-specific employment manuals as the first layer of defense. Remember, we talked about compliance and good habits as the first layer. That's a really basic thing that many doctors' offices have cobbled together, or the office manager has begged, borrowed, or stolen, and crossed out New Mexico gynecology and written in Scottsdale cardiology. That doesn't work. So that's one issue, is employment lawsuits. The average sexual harassment verdict, as one example, is $530,000 and can cost several $100,000 just to defend. So that's an example where a physician's office should certainly have EPLI, or employment practices liability insurance. That's one of many non-medical or non-malpractice professional risks that physicians face. And we try to identify a bunch of those when we talk to clients, but that's just one really specific example. Now, with the current crisis, with COVID-19 coronavirus, we have all kinds of additional healthcare law compliance issues, ranging from employee screening to employee leave issues to are you keeping employees' health screening results separate from their personnel files to maintain HIPAA compliance, right? So there are lots of other professional risks. Then if we look at personal risks, do you own a home? Do you drive a car? Do you serve on a board? Do you have an executive title at your practice, like president, CEO, CMO? Do you have kids who are off for the summer driving your cars, using your boat and your RV during the 100 deadliest days of the year, which goes from Memorial Day to Labor Day? Do you own assets that generate liability, right? Like, do you own a rental home? Is it in your own name? Could you get sued if somebody gets hurt there because you don't have it wrapped in an LLC? So we identify typically a dozen other risks for doctors that have nothing to do with their practices, that are common everyday risks that nobody ever sat them down and walked them through and said, hey, do you have an umbrella policy on your home and your cars? I mean, something that basic is still overlooked by many physicians and their advisors. I know your clients are better advised, but I talk to millionaire physicians every week who have $500,000 or less in car insurance. Those are some of those risks, just to give you just a few specific examples. So these kinds of things sound silly, but the everyday exposures are more common than people think. It is not always the big catastrophic med mal suit that's going to be the first thing that threatens a physician's wealth. It's going to be something like a car accident or a business lawsuit or an employment lawsuit that makes them feel the shadow of the reaper the first time.
No, that's excellent. Barriers, layers of protection, personal, professional, all these different types of things. And because I've been fortunate to read a lot of your content, I hear you use the phrase target value an awful lot, both in our conversations as well as in your written articles. If you could kind of set the context of what is the target value, why is that important, why do people need to know what their target value is in this concept of asset protection?
Sure, and I've actually written a really short article that helps people figure out what their target value is. I'll be happy to send that to you in case it's a link you want to post with this that may help some of your viewers. But target value kind of is, what are your collectible assets, right? Do you have equity in your home above homestead, for instance, in your state? And it varies so drastically. We have a couple of states where it's unlimited. And then we have the rest of the states, the majority of the states, where there is homestead protection, but it's insufficient, especially for the kind of successful people that you and I work with, who tend to take their investment in their home seriously in many cases, right? So that's one issue is, how much of your home equity is exposed. Another part of you calculating target value is, do you have multiple income streams that are exposed? So maybe you and I are talking to a physician who has 4 rental properties and an interest in an ASC, and they have a membership interest in 5 LLCs, right? And they are the member in each of those LLCs themselves, or their revocable living trust is. And they come to me or you, and they put that down on the table and they say, well, I'm safe, right? I've got these LLCs. And I would look at that and say, yes, I can't take the asset from you, and I can't take the LLC away from you, but if I'm suing you and I get a judgment, I will take every dollar that comes out of those investments and comes to you. So income stream protection is part of target value. Where are your non-qualified assets held? Are they in your own name or in the name of your revocable living trust? And if they are, those are available to your creditors as well. So all that money that you've worked so hard to save, and all those extravagances you skipped so that we could bring Anthony more money to smartly manage for us, needs to be properly safety wrapped. Now, why do we worry about that target value? Because that is part of the calculation that's made in the attorney's office. You know that I've been doing asset protection planning for almost, going on 20 years now, but before that, I was the bad guy on the litigation side. We don't sue two kinds of people who don't have money and people who have money we can't get, right? Why would a attorney's office pursue a doctor beyond the limits of their med mal coverage? Because they're collectible. If the person is not collectible, then a settlement within the limits of your insurance company becomes more likely. The plaintiff's injury attorneys don't want to spend time and money obtaining judgments that are beyond what they can actually collect. So part of what this does, part of what knowing this does, and I think this was your question, why do you need to know? You need to know if you're worth suing beyond the limits of your insurance, and if losing those assets would be a problem for you, if they'd be difficult or impossible to replace, if you don't want to have to earn the same money twice, then you need to do something about it and shelter those assets in a legal way before there is a problem. one of the other challenges is that we have, that I have, and that you have as an advisor, is that most folks don't worry about this until something bad happens. And then they want to make the heroic changes that we should have done under blue skies when they are prohibited from doing so by the law and when it is fraud.
So if I'm thinking about this and I'm a viewer right now, I might be a little freaked out. I'm like, holy smokes, this guy has just said all these different things. Maybe I've done some legal planning. Maybe I haven't done some legal planning, but how do you take stock of that? Like, how do you crash test or audit your legal planning? What would be the steps involved for something to figure out, am I good? Am I not good? How do we deal with that, Ike?
Well, there are a few ways to do that. One is obviously to consult, with a professional, right? And I understand what you're saying about scary stories, and that this can be perceived as negative, the conversation that we're having. And I think that's not my intention, and it's not yours. But smoking's bad for you, whether you know it's bad for you or not. Somebody needs to tell you, or you need to find that out. So I think that education is, maybe we should put education as the first line of defense in asset protection planning and adjust my chart. But being educated about these things is very important. In terms of looking at your planning and crash testing your planning, there, in the course of talking to a professional, many of those issues will be discovered, whether they're talking to somebody like me or somebody like you. We're going to find those weak spots, right, as part of our process. That is part of our diagnostic process for the physicians, especially that we're dealing with, right, is to look at the fact pattern, look at the patient holistically, and look at, what are the risk factors that they present, and help with that. Obviously your documents can be reviewed to make sure that they're complete and up to date and do what you think they're going to do. But there's actually an even simpler way to do that. And again, I'll send you a link. I came up with a list of, let's call it 24 questions that every person can go over themselves or with their advisors to help figure out what kind of gaps and exposures they have. And so it basically helps you ask yourself questions like, do I know what would happen if there was a lawsuit above the limits of my insurance policy? Do I know who is in charge of my estate if I were to pass away? Am I comfortable with the amount of income that my family would be left with if I passed away today unexpectedly, right? So these kinds of questions will help crisis test your planning, and they can be done in sort of a self-exam that I'm happy to share with you, for you to share with your viewers. And they can ask themselves these questions, and if they're unhappy with the answers to those questions, then they can certainly seek help with any of those specifics. Does that make sense?
Absolutely, and I will definitely take you up on your offer to include that when this drops. That list would be perfect to have in this series, if you're
right.
willing.
And look, I have the list, and I know our time is limited, and I don't want to spend a bunch of it reading the questions, but
Sure.
Some of them are as basic as, do you have an estate plan? If you do have one, does your family know about it? Is it up to date? And are you still comfortable with the people that you named to be in charge? Right. We ask questions like, if you own your own practice, how long would your practice be able to pay all of its fixed expenses like rent, salaries, and insurance without you personally producing income or going into your personal savings? This has been a bigger issue, especially lately, when we've had so many medical professionals affected and infected by COVID-19 themselves, right? So asset protection isn't just about lawsuits, it's about all your real world risks.
Which is exactly why I wanted to do this series, and why I wanted you to be a part of it, is what are all of the risks holistically? How do we preserve our wealth as all these various I don't like to use the word armies, but I have a slide in one of the presentations I do that says, what can we learn from Game of Thrones? And then it just has a picture of Jon Snow amongst other people. And that's the slide in my deck. And, you know, I'll ask folks, what do you think that means? And they're like, dragons, you know, I go, no, layer upon layer, barrier upon barrier, acknowledgement and education of the risks that we have, and then strategies and tools to make sure to mitigate those risks where possible, which I think if I could, I'd like to pivot. That makes me think of, we've talked about a lot of these different things. What are some of the most common asset protection mistakes that people have made in your experience?
Sure. Well, the first one is easy. The biggest one is always the same. It's doing nothing, right? So if you've worked hard, you've accumulated wealth, you've followed good habits, if you don't do something to protect your wealth and manage some of those risks that we talked about briefly, that wealth is at risk. So that's number one, is doing nothing when you can and when you should. And we turn down, I personally, just me, not my firm, just the people who end up on my phone line, I turn down at least 4 people a month who call us after something has happened. A second most common fatal flaw of asset protection planning, of again, the list that we can provide for you and your viewers, is relying on traditional estate planning alone. So what we see there is many people have their primary residence and their non-qualified assets that are in taxable accounts, and their personal property and many other things in their own name or in the name of their revocable living trust. And they are unaware that that revocable trust does not protect you from your liability during your lifetime. Okay, so it is a fabulous estate planning tool. I make people implement it every day, but it is not an asset protection tool. Another common fatal flaw of asset protection planning, one that doctors love, is passing assets to your spouse or other relatives, right? I don't own anything. I don't need to worry about asset protection. My wife owns everything. That is a common thing I hear from physicians who are doing do-it-yourself planning or out on the internet, you know, looking for techniques. Here's a couple of basic reasons why that technique, so beloved by the medical community that you and I love and serve, doesn't work. Number one, if you give assets to somebody, including your spouse, in a formal way, where you title transfer, you do a post-nup agreement, you have a property commutation agreement, whatever it is you do, if you get divorced, that's her or his money, okay? It is that will not be included in the marital estate to be divided. The marital estate will be divided and they will keep that separate property. So that's one big mistake when 50% of Americans get divorced, right? We're close to 50% divorce rate. So giving somebody that property severs your future rights. And there are cases that say in a divorce, you can't go back and say, oh, Your Honor, yeah, we did that, but I was just kidding. It was a big scam to avoid creditors, right? That's a tough argument to sell. It also fails because that person now holds title to a valuable asset, and their liability can affect that asset just like yours was. So sometimes spouses think, oh, I'm the physician's spouse and my spouse does something else and they're lower risk. So we're going to transfer the assets to the other spouse. That spouse still has risks. They could be involved in a bankruptcy. They could kill someone with their car. They could, leave that property to anyone you want or die intestate. So lots of things can happen, and that's not good planning. And those are just a couple of the reasons that, as I said, you're substituting one person's liability for another without actually distancing the asset from the liability the way it should be. Another common fatal flaw of asset protection planning is relying on insurance alone. Look, you heard me talk about insurance ahead of my own legal planning. Dollar for dollar, it's your best and most predictable line of defense. But insurance can't do everything. You can't just buy an umbrella and say, well, I'm protected. Great, you've got a $5 million umbrella on your home and your cars in case you or your spouse or your kid kills somebody. That's not going to protect you from an employment law claim or a HIPAA lawsuit or a data breach claim or a shareholder lawsuit or a D&O lawsuit because you're a director or officer or because you served on a bank board that made some bad loans. Banks love to put, and other organizations love to put doctors on their boards because it adds prestige to have, John Q. Smith, MD. So there are lots of those liabilities out there. And as important as insurance is, it is naive to think that you can write a check that will protect you from anything and everything that will ever happen, no matter how much it costs and no matter what the circumstances are. So yes, insure, but have a backup plan. Those are 3 out of maybe a dozen very common fatal flaws. And again, I'm happy to share the list with you.
That'd be great. And, we're talking about mistakes, and this just occurred to me while you were chatting. And so you and I both, we get around the country, although right now not so much, but in general terms, we're around the country, we're speaking, we're at association conferences, we're doing all these different types of things. And there are companies that are at these conferences that are talking about promoting as asset protection. And of course, they have a great audience. They have people who are making a good income. They have people who presumably have some assets accumulated to this point, and they're on the stage and they're doing all this type of stuff. And I'll have clients that come to me from time to time. And of course, I want to be tactful. I want to be professional in my discussion of this. Moreover, I say I really need to put you in touch with a real asset protection attorney. Would you mind talking about some of these entities that are speaking at these conferences that seemingly to a layperson, oh, this is asset protection planning?
Sure, Anthony. And in fact, again, not to sound like a broken record, but I've actually written about this a number of times because clients have brought it up, as have advisors. I think what you're referring to are the promoters that are often at medical conferences who in many cases are not attorneys, who are selling kits that often sell on creating LLCs and do-it-yourself planning. They offer legal document preparation, but not legal advice, right? So that's like giving somebody access to an ASC and a laser, but not giving them a doctor. What could possibly go wrong? I think that's a good analogy. If they're not attorneys, they don't have attorney-client privilege. They don't have malpractice insurance. They don't have any liability for any advice they give you, correct or not. They don't have any liability for the promises they make about what their planning will do. In many cases, those kinds of folks center their planning on selling you a series of LLCs, for instance. And LLCs are great tools if they're used for the right purpose, but they can't be used as a trash can, right? So you can't tell somebody, set up an LLC and put your home and your cars into it, for instance, because there's no legitimate business purpose for that and it would be easily defeated. In many cases, if they use that trash can approach, they also mix 2 different liabilities. So let me get this straight. An LLC owns your house and your cars. If you kill someone with the car, we're going to sue the car's owner, which is the LLC, which also owns your home, right? So these common sense things are obvious to me as an attorney, but it becomes difficult for consumers at a conference when somebody has taken you to a nice lunch or dinner and shown you a bunch of neat slides and has a nice looking website with a name that even sounds like a law firm, right? It's, Smith, Johnson and Associates. Well, you might think that's a law firm, but you should ask very specifically, who are the attorneys who will be representing me? Is this an attorney-client relationship? Is our correspondence attorney-client privileged, or could it be discoverable in the future by a plaintiff? And if the person you're talking to is a promoter and not an attorney, then they don't have any of those benefits. They're not giving you advice. Their documents explicitly, in many cases, state this is not legal advice. We are just helping you file the document and record the LLC. One of the clients that came to me with a plan like that in place, first of all, he was relieved that nothing happened during the period that he was relying on that, because it was in place for a couple of years. And then a CPA saw it and said, hey, this this is nonsense. This isn't going to work. And I'm not a lawyer, but you should talk to one. And when we saw it, we agreed. He was relieved that we discovered it, or that his advisor discovered it before there was an exposure. He gave me the information on the folks who put him into the plan, and I looked up who they were. The person who sold it to him previously sold nutritional supplements. That
Wow.
was the speaker at the medical conference. And I'm not saying that anyone who sponsors an event is a villain. I'm absolutely not saying that. I'm saying it should be part of what you look at.
Absolutely. No, sorry, that just occurred to me as we were kind of talking through some of this stuff, but we're pushing up on the time frame. Ike, I really appreciate your time. I feel like I started out today with this whole asset protection narrative, and this series that we've put together on wealth preservation really started with our conversations, and you're educating me, frankly, on the importance of these types of things. So I appreciate your time to cover, and I realize we could probably sit here and talk for another 3 or 4 hours if we wanted to, but I think in the interest of time, we'll wrap things up, and I will say thank you. Any parting words of wisdom or any final comments you'd like to make before we wrap up?
I'll just say that as we move forward into what is now, I guess, officially a recession, and at best a very uncertain economic future, I would advise folks who are watching this to use the help of professional advisors like yourself to do something to protect themselves while they can, because if we move further into troubled waters like we saw in 2008 and for about 6 years afterwards, there isn't going to be a lot you can do when there is a problem. Economic duress causes lots of people to make claims that they might not ordinarily have made. People get scared and angry, they look to protect themselves with litigation during recessions, and now is the time that you need to be preparing for that if you haven't already.
A great way to wrap up. Ike, thank you, sir, for your time. I appreciate it.
Thank you so much for having me, Anthony. It's good to be with you.
You bet. Cheers.